Excuse me.
Okay, commissioners, you're live now, and it looks like you do have a quorum in attendance when you're ready to call to order.
Go ahead, Jeff. Get us going. Call a roll, please.
Okay. Commissioner Hopkins.
Present.
Commissioner Johnson.
Present.
Commissioner Jackson. I see him on there, but I didn't hear a response.
Here.
Okay, now I heard it. Thank you. Commissioner Young.
Present.
Commissioner Burrell.
Yeah.
Commissioner Cawthorn.
Present.
Commissioner Gage Watts. Commissioner Taliaferro.
Here, sir.
Commissioner Atkins.
Here.
Commissioner Chavez. Commissioner Lazarus.
Here.
And Commissioner Epperson.
Present.
All right. Looks like y'all have a quorum, that you have 10 in attendance and 2 that are absent. And that would bring us to the invocation.
Okay. Commissioner Hopkins, can you do the invocation, and Commissioner Atkins, can you do the pledge?
Yes, sir. Yes, sir.
Thank you.
You join me and bow your head, please. Dear Heavenly Father, thank you for this day you've given us. Go with us as we go through this meeting to serve the people of Caddo Parish. Give us wisdom. Give us a good understanding of what we're doing. Be with us as we go through our daily duties in our communities. Be with us as we go through with our families. Keep us safe. Keep the citizens of this parish safe. This we pray. In Christ's name, amen.
Amen. Amen.
Okay, if we could all stand, please. Veterans, feel free to issue a brow salute. All others, please place their hand over their heart and recite the Pledge of Allegiance. I pledge of allegiance to the flag of the United States of America and the republic for which it stands, one nation, under God, indivisible,
with liberty
and justice for all. Thank you.
Next item, Mr. Clerk. Thank you, Commissioner Atkins and Commissioner Hopkins.
Yes, sir.
Jeff's screen just froze. So we move to the certificate of teleconference. There's no action that needs to be taken. And if you guys will hold just one moment, I'm going to try to get Jeff up and running real quick.
Okay.
Hey, commissioners, this is the clerk. I'm sorry, my screen froze when I was trying to share the flag for the pledge, and so we are going to try to get that fixed. But for right now, I'm joining you from Michelle's computer. So she did just mention that we have the certificate of teleconference attached, and there's no action required. The next items on your agenda are ordinances for introduction.
Well,
And if it would be okay at this time, we would like to read an updated notice of intent on these ordinances.
well, hold on, Mr. Clerk. First, we got to find out if there are any agenda additions. If I'm looking at the right agenda.
We're
Yeah.
actually not allowed to do agenda additions during these special teleconference meetings.
Right, but it's on the agenda, so I just wanted to make sure that.
Thank you. Yes, thank you
Okay.
for acknowledging that. We should say that. So thank you for doing that. And you're right, we still haven't done citizen comments as well.
Right, that's the next one.
Sorry, and the transition between the computers, I got lost on the agenda. So we have not received any public comments, but at this time we will share the phone number is 318-226-6596. Should anyone choose to call in. But again, we have not received any electronic communication for public comments for today's meeting.
Okay. Next item.
So next we have public hearings on ordinances. We don't have any today. And then ordinances and resolutions, we also don't have. That does now bring us to new business, where is the appropriate time to notice the certificate of teleconference that's been updated in compliance with the new changes. And that brings us to the introduction of ordinance 5963.
Okay.
Would you like me to go ahead and read that updated notice of intent?
Yes.
It's relative to the ordinances. So if we could, and this is just in an abundance of caution, these millages are important, so we want to make sure that we properly notice all of it. And we need to deal with some changes in the notification timeline. So I will go ahead and read it. Notice is hereby given that the Caddo Parish Commission of Caddo Parish, Louisiana, the parish, plans to consider ordinances to adopt, levy the parish's ad valorem tax millages for properties within the parish of Caddo at the meeting on Thursday, September 17th, 2020 at 3:30 p.m. at the Government Plaza Building, 505 Travis Street, Shreveport, Louisiana, or via teleconference in accordance with Louisiana Revised Statute 4217.1. At this meeting, the parish will consider adoption of its general purpose millages, special purpose millages, and debt service millage. The parish will also consider adoption of the values fixed or to be fixed by the Louisiana Tax Commission on all assessments for railways and other public service corporations, and considering the assessment of property classified as timberlands. So that is the updated notice of intent. We have read a similar notice of intent, but the difference is that we're allowing some more time for public comment.
All right. Thank you, Mr. Clerk. Next item.
That would be the introduction of ordinance 5963, which is an ordinance to set the general purpose and special purpose millages, providing for millage rate adjustments as allowed by Article 7, Section 23 of the Louisiana Constitution of 1974 and Louisiana Revised Statutes 47:1705B, levying and imposing taxes and assessments for 2020 on all the property subject to taxation in the parish of Caddo, and to otherwise provide with respect thereto.
So move. Second.
And this
It's been
is
moved by, oh, that's
Just
the
for
introduction.
introduction. Just for
Yes.
introduction.
correct.
Go ahead to the
And-
next.
The next one, please.
The next one is going to be the ordinance 5964 of 2020, an ordinance setting the assessment of property classified as timberlands, and to instruct the assessor to include said assessment on the tax roll of the parish of Caddo for the year 2020, and to otherwise provide with respect thereto. And then the introduction of ordinance number 5965 of 2020, an ordinance to adopt the values fixed or to be fixed by the Louisiana Tax Commission on all assessments for railways and other public service corporations, and to instruct the assessor to extend such assessments and values on the tax roll of the parish of Caddo for the year 2020, and to otherwise provide with respect thereto. The next item is introduce ordinance number 5966 of 2020, an ordinance setting the parish millage for the purpose of paying principal and interest due in 2020 on outstanding parish bond issues, and to instruct the assessor to include said millages on the tax roll of the parish of Caddo for the year 2020, and to otherwise provide with respect thereto. The next item is introduce ordinance number 5967 of 2020, an ordinance amending the budget of estimated revenues and expenditures for the general fund for the year 2020 to provide an appropriation for COVID-19 testing sites and small business support by issuing COVID kits, and to otherwise provide with respect thereto. And the final item in new business is resolution number 58 of 2020, a resolution electing to hold meetings pursuant to section 17.1 of Title 42 of the Louisiana Revised Statutes, and to otherwise providing with respect thereto.
So that resolution we can take motions on.
Yes.
Mr. President, could I ask the legal counsel to advise on this matter? Is this,
Well, we can do that when we get to, if we get a motion and a second.
I move the resolution 58 of 2020.
Second.
It's been moved by Commissioner Epperson, seconded by Commissioner Burrell to advance and approve resolution 58 of 2020. Now, question, Commissioner Atkins.
No,
Well,
sir.
well, Commissioner
Motion.
Epperson, since you made the
Okay.
motion.
Right.
I'm a
Mr.
little
Chairman,
rusty.
I consider this to be relevant. It's dealing with the COVID issue, the reason that we are having a special meeting today. So therefore, it is perfect within our purview to entertain this at this time.
Mr. Chairman, or Mr. President, just to be clear, I'm not questioning its relevancy. I just want to make sure that everything in this resolution is appropriate with respect to the some of the legal issues we've been facing regarding when we can and cannot do teleconference meetings and when we must do in-person meetings.
Right, and I think that's up for a bunch of interpretation. So you asking legal now to speak on that?
Yes, that seems like it'd be appropriate to hear their position on this because frankly, yeah, there's a lot of interpretation and I don't have a strong view on it. I'm just trying to get some clarification on it.
Okay. Legal, I see Henry is done on.
I
Okay, I
am.
see both of them on. Okay, so we got both our attorneys on.
Commissioner, it's my understanding that what's to be accomplished by this resolution is basically you all are declaring that you are meeting under 42:17.1, which is the teleconference agenda with the 3 categories of items. And that's going to be your regular meeting for the remainder of August. So it would be for your next set of meetings because I believe we only have one more set of meetings in the month of August. And that is the only kind of meeting that you're going to have.
Okay, and I don't have a problem with that as long as it's legal to do so.
Well, yeah, it would be a meeting pursuant to the statute like this one.
Okay, I see what you're saying. All right. So as long as we stick by the ground rules, the 3 ground rules laid out in that statute, that we would conduct all meetings where we could confine the agenda to those rules, and other issues would just be pushed back till September or October.
That is my understanding. What this would do that's different from what you've done this week, whereas you've had 2 meetings this week with 2 different agendas, what you're saying by adopting this resolution is you're going to only have the one limited agenda meeting via teleconference.
Okay, that's very helpful. Thank you, Ms. Frazier.
I'm not quite understanding, Mr. Chairman.
Okay, get on the board. Get on the board. I got Commissioner Young and then Commissioner Jackson.
Thank you, Mr. Vice President. The way I understand this resolution is just that legal has alerted us to a new rule that governs our online meetings. And the new rule has specifications, which some of our agenda items that we had been talking about don't fit. And so this is my understanding of an agreement that instead of 3 or 4 or 5 or 6 of us showing up at a meeting when other people aren't going to show up at a meeting, just for like the proper reason to obey health directive. That instead we would just meet online with a limited agenda, and we could use the communique section of an agenda, which I hope we still have, to discuss our plans and the issues that we want to deal with when we meet in the chamber again and have an unrestricted agenda. So I'll be supporting it, and I thank our legal team for their alertness and their making us aware of the law as it changes, and for their, I think, obvious interpretation of it. It also has a clause in it that mentions that our legal team will pursue and advise us on how to challenge this rule, if we should choose to challenge it. All the associations of governing bodies below the state level in our state have objected to it to the governor. I think that there are other plaintiffs and that we could sign on to a lawsuit or participate at the head of a lawsuit with a bunch of people who would rather be able to do our whole meetings online. But in the meantime, I think it would be fine for us to restrict ourselves to the legal topics. The law also says that the president, who's absent right now, has the authority to name an agenda item as appropriate under the emergency video meeting rule. And he may want to do that for some items that currently aren't on the agenda or not as they come up in the future. And I think it could also be his option to ask the group for their majority vote opinion about whether something should be included or not under the statute before deciding whether to put it on the agenda or not, because he has to sign off on it. And I've also been made aware that we're all personally liable for breaking this rule. And I suppose that it was passed in order to make us follow it. So I think we should be aware that we have to follow rules, but we can object to them as we follow them. And that's the legal way to go about changing the law. Thank you.
Commissioner Jackson. You're still muted. Okay.
Yes, I will no on this resolution. I think it confines us. I think the definition. I think the definitions are subjective. It allows one person to be subjective and dictate what the items on the agenda will be. And I just don't think that that's fair. Because if we want something on the agenda, for instance, we did not get an opportunity to consider several things on Monday because of this format. And the idea was that the state law restricted it. However, if you're telling me that the items that I put on the agenda are not of emergent issues, who is to define what is an emergent issue for District 3? I represent District 3. Ken Epperson represents District 12. John Atkins represents District 9? Who is to say what is emergent, what is not emergent in your respective district, or for the parish for that matter, collectively? And I do not see where the state law that was enacted creates that restriction. I think it has been interpreted incorrectly. And I agree. It is legal's responsibility to give us what the black and white letter of the law is and tell us what it is. It's up to this commission body to determine what goes on the agenda. And I think we're manipulating our agenda, trying to restrict it to only certain matters. And I don't think we should do that. I don't think that was what the law was intended to do. I'm looking at New Orleans Parish Council met this morning, and they had a zoning case that was heard this morning that had absolutely nothing to do with COVID-19. They had a zoning case. They did all their zoning hearings this morning. Why should we restrict our agenda in such a way? East Baton Rouge School Board, they met via Zoom and considered all of their matters before them.
Hey.
I'm sorry, can you hear me?
Yep.
Oh, I thought somebody called my name. They considered all for them. I will be meeting next week for Louisiana Housing Corporation. We're going to consider all of the items we normally would consider on a normal agenda. Same thing, our qualified action plan. These are items, if you go back a year, if you go back a year from today, these items or these type of items would have been on there prior to COVID-19. So how is it that Caddo Parish is going to be the only jurisdiction in the state that's about to take this approach? I do not understand why we would do that. And so I will not be voting in favor of this resolution. Thank you.
Mr. Chairman,
Commissioner Burrell, you up?
thank you, Mr. VP. Given that there's so much controversy over this issue, I sent to some of my fellow colleagues, because it was sent to me, a situation down in Alexandria where a gentleman, council member, I think he's 98 years old, that kind of fell under the rule of SB 302, or should I say, kind of contrary to the rule of 302. And there was a federal ruling, as I understand it, a judge who ruled that that individual, because of age and underlying conditions, that they could not force him not to participate in the business of the city, representing their constituency. I know that several of us meet that criteria, not just Ken and myself, but I think there's more than them that are over 65 first, which is the first criteria that the CDC gave. The second thing basically was the underlying conditions in which, you know, if many of us would admit, we probably do have some underlying conditions that would be conducive to harm, you know, by this virus, because it is one that you cannot see and detect, and every day they're coming out with some new issue associated with it. I just looked this morning that another one of our Republican congressmen found out that he had COVID. He was testing every day. His temperature, one of the first criteria was looking at his temperature as a quick check to see if he could possibly have it. His normal temperature is 97. This was 99. And their criteria for detecting it is over 100. He was getting ready to go back to his family and could have spread it because he was basically asymptomatic. So I'm saying all that to say this, you know, these artificial rules that are set forth in SB 302, in my opinion, and excuse my French, is a bunch of BS. Because COVID, and I'll say it again, don't give a damn about whether you're talking about emergency issues, COVID related issues, deadlines, or what have you. You can catch it up to gazoo by being in a situation where you don't have full protection unless you're in a bubble suit. So I'm trying to understand, for the life of me, not being a partisan in this case, why are we putting ourselves in jeopardy? Not just those who are over 65 and underlying condition, but you, my fellow colleagues, whether you're white, black, green, or blue, Republican, Democrat, Independent, or what have you. I think some of us sometimes have to stand up to protect your interests. You said, well, you don't have to. I can protect my own. No, that's not true. Because by protecting you, I'm protecting me. So from that perspective and that logic, I'm not understanding why, if Alexandria, that situation down there, which to me applies to this, why we don't do a lawsuit if necessary to try to deal with this. So I'm saying all that to say this. I'm making a substitute motion, Madam Attorney, that we do file a lawsuit to kind of, you know, put our interests forward You can vote it up or down, that's fine. But this is very serious to me because I have people in my family now that I found out my daughter-in-law has it. She couldn't even go to her son's graduation. My niece's mother has it. She's a registered nurse. So this stuff is serious. You need to take it serious. So that's my substitute motion, Mr. Chairman, that we do file that lawsuit. I don't know what the language is going to be, but that's it. You know, vote it
Well,
up or down.
Commissioner Burrell, I heard your motion, but you had already spoke. And so what you would have to do is get back on the board to make your motion because you had the discussion before the motion. And in our meetings, you have to make the motion first, and then we do the discussion. That's what I've been taught.
Is
Yeah,
that in the
that's what I've been.
Is that in the fine print? If so, would it send me that information? Not that I question the VP. You all have been there longer than me, and I know you all have the commission has a certain protocol. I know the protocols in the council and the state. I'm learning the commission, so I'm not disrespecting. You know,
as the parliamentarian, I can back up the suggestions of the vice president.
Okay, then. Well, at such time, Mr. Chairman, I'll do that.
Okay,
so
you can get right back on the board, right? Got Commissioner Jackson, that's the one up, and Burrell right after him.
Yes, I make a motion that we continue meeting as we have been meeting, utilizing a full agenda on Zoom, and that legal will begin preparing or researching avenues for legal means to challenge, I guess, Act 302.
I can second that.
So we have a motion on the floor from Commissioner Jackson, and it's been seconded by Commissioner Burrell to continue to meet as we are by Zoom, and for legal to the full agenda, and for legal to find ways to make it work. In so many words.
Commissioner, no, that he said for legal to research means or come up with the means to legally challenge it. He didn't say anything about making it work.
Oh, okay. That was my bad interpretation then. Commissioner Jackson, we're open for a question.
Yeah, sure. And I'm not talking about special resolutions. I'm not talking about special proclamations. I'm talking about ordinances that we normally would be considering that deal with the day-to-day aspects of Caddo Parish, the day-to-day operation of Caddo Parish, and things that we do on a normal basis. So I'm not talking about those special things that we try to do, but I'm talking about our agenda as we would have it. So if there's an ordinance to amend the budget for a program at Susla that we didn't get to consider, then we need to do that. I think that was something that talks about some early voting locations. We didn't get to discuss that on Monday. Those are things that are critically important to Caddo Parish and to our day-to-day functions. And I think those are admissible. Again, I'm looking at Orleans Parish. Orleans Parish had a 50-page agenda this morning where they met on a host of issues, from zoning permits, from historic, designating places, historic locations throughout Orleans Parish. They've met, and nobody's down there being carted off to jail. Nobody's down there being given a civil fine. 50-page meeting. East Baton Rouge Parish has already met. Their agenda was 93 pages. So again, why should we be any different from anybody else? Thank you.
Mr. Chairman, since I seconded, do that give me any privilege to comment?
No, but I see you on the board. I got let's see, Young, Telefaro, Burrell, and Epperson.
Mine could just be a point of clarification if that's the case.
Well, you're already on the board, so
No,
Young,
that's fine. Go ahead on. I'm good.
Teleferro.
Okay, thank you, Mr. Vice President.
Okay.
I think I agree with Commissioner Jackson about nobody being carted off to jail. I think that's probably true. There's a 60-day window in which an agenda can be challenged. I think that this week is maybe 2 weeks too early to file a lawsuit. I do think that it would be good for our legal team to talk to many other organizations like ours and our associations and see if there is a group interest in filing a lawsuit next week so that we can talk about anything we want, just like we would. Since the only thing we do here as a body is communicate, we can do that perfectly well on Zoom, and the public can participate perfectly well on Zoom. I think next meeting would be a better time to decide whether to go ahead suing than this week. And I also want to reiterate that our president, or perhaps if he's absent, our vice president can put things onto the agenda by certifying that they fit the rule. And if and I think it is a little unfair to force the president to make that decision on every case, just as it can be unfair to have an agenda item excluded. I don't think that that's precisely the job that the president expected to be doing right now, was choosing whether or not something was allowed to be on the agenda. So I suggest that if we want to go ahead by following the rule, the president could refer to majority opinion informally, but by a vote, and then consider that in making his opinion, making his decision about whether or not to put something on the agenda as conforming to the rule. And then in 2 weeks, after we consult the attorneys from these other places that seem to have more extensive agendas, we can go ahead and follow their attorney's advice in conjunction with our own attorney's advice in good faith, perhaps, or get together and file a legal complaint while continuing in whatever manner we choose to after that. So for this particular motion, I'll vote no, but next meeting, I might vote yes. And I think some of Commissioner Jackson's concerns would be answered partly by some of the solutions I mentioned. I know that probably not completely, but maybe soon more completely. Thank you.
All right, Commissioner Teleferro, and then Burrell and Epperson.
Thank you, Mr. Vice President. This is more for legal. Is since that we have a mandate or a directive, I don't want to say the word mandate, and maybe I'm confused, so you can straighten me out, and I don't have an issue with that at all. Since we've been directed by the governor's office to go ahead and resume, I'd say, for lack of a better word, live in chamber meetings when necessary, and eliminate, I guess, the Zoom meetings. Is that something we need to continue until we do initiate a lawsuit? Or, and this is a legal issue, is if we do initiate a lawsuit, is the commission initiating it on behalf of those members who wish not to attend or wish to stay isolated, so to speak? I'm not exactly clear on how that would work.
Commissioner, starting with your last question first, whether it would be on behalf of individual members or whether it would be on behalf of the body, would depend on what theories of cases you present and what you decide to vote to tell us to pursue. If we are able to come up with a theory under which the body could challenge the law, then it would be up to the body. If the body votes to pursue that, it would be on behalf of the commission as a whole. If the body did not vote to pursue something as the commission as a whole, it would be up to individuals to sue in their own behalf. The only way we can sue on behalf of the body is if the body authorizes us to do so on behalf of the body.
Okay, and I understand it, and thanks for the clarification. So going forward, is it in our best interest to continue with the directives out of the governor's office and then go ahead and pursue legal action if that's the will of the board.
The directive actually it's a change in the legislatures. It is a change in the law. It's not a directive from the governor's office. And what you would do, you would need to proceed according to the directives that are within the law, according to those categories, and simultaneously file a legal action. But you do not want to, the way I would put that is, you don't want to take a chance of having something that you have done challenged without your cover from a court ruling.
Yeah, I think that was my concern, is that it's safer to go along with the way we're doing it. In other words, the law now and then challenge it later. I'm just concerned about us, getting called on the carpet for, going rogue, so to speak.
My advice would be that you would continue per the directives of the statute until you get a legal opinion or a legal ruling, saying that you can do otherwise.
Perfect. Thank you. Thank you, Mr. Vice President.
Okay, Commissioner Burrell, and then Epperson, and then Atkins, and Jackson.
Okay, thank you, Mr. Chairman, Mr. President, Vice President. First of all, I'm trying to get a clarification based upon what had just been said. First of all, making a statement that I supported Commissioner Jackson's resolution, or seconded over mine, because he said that we would be able to hopefully continue our Zoom meetings until such time that we challenge this SB 302, because just looking at what they did in that Alexandria, that situation would violate SB 302, but a federal judge said, no, it's a special exception because of age and underlying conditions for some of us, and that we could continue on Zoom because it does not violate, violate whatever their charter is down there, that they will still be interacting with the public, they will still be taking care of the business, but it would also be protecting the welfare of their representatives, whether it is a situation that deals with age, underlying condition, or in this case, we have half of our commission are minorities, and there have been a lot of data out there that we are 70% more affected than our counterparts. So that is an added concern, and that would fall under the criteria of this SB 302 to continue our Zoom meetings. So under those circumstances, I'm not, I could support, Jackson's substitute motion. Secondly, as a point of clarification, does it also say in there, Madam Attorney, that the president has the discretion similar to what we do in the state legislature, where the Senate president and the I was in the legislature, I forgot who it was.
Speaker of the House.
Speaker of the House set the agenda. Isn't it also stipulated in this bill that the president and the president can help set that agenda, and he has also added our vice president to it, so we can have some diversity in political structure as well as in the area of race. So So I guess my question on that is, Madam Attorney, wouldn't that allow them the flexibility to continue to Zoom versus not continue to Zoom on these items that are stipulated in there?
Commissioner Burrell, there are two things I need to address. One is the Silver opinion out of Alexandria. That opinion is because Mr. Silver filed a personal action against his counsel saying that they were not allowing him accommodations under the American Disabilities Act and the Rehabilitation Act. That lawsuit was filed prior to any governor's proclamation regarding the pandemic and Zoom meetings, and it did not take into account 302, except to mention that 302 had been passed after the lawsuit had begun. So that is not a lawsuit about the provisions of Article 302. It's about whether or not they had to make accommodations for him to attend meetings by phone due to him being covered under the American Disabilities Act and the Rehabilitation Act. The very first paragraph of the opinion before the court is a motion for preliminary injunction filed by Harry Silver, an Alexandria City Council member who represents District 4 of Alexandria, Louisiana. Mr. Silver is 98 years old. He suffers from significant inoperable aortic valve disease and systolic heart failure and has a permanent pacemaker. He contends that these medical conditions, which substantially limit the operation of his cardiovascular system and his reliance upon a pacemaker to regulate his cardiovascular system, render him disabled as defined by Title II of the American with Disabilities Act and Section 504 of the Rehabilitation Act. That's what that lawsuit is about. I have stated before in email that if any commissioner has a disability that we can certify, then I think we would be able to rely on Silver certifying a disability for a commissioner to participate in any kind of meeting via electronic means. That's what this says. If you are certifiable under the ADA or the Rehabilitation Act, then you can participate electronically. So I want to make that clear. That doesn't say that 302 gives you unlimited meeting power or anything of that nature. The second thing is that the provisions of 302 certify or have there are three categories of provision. There's not just one category. It's like, oh, it's not COVID related, we can't meet about it. Or, oh, it's not an emergent issue, we can't meet about it. It says that you can do the business, the day-to-day business, and that business has to have a deadline that needs to be met. I have not looked at all the agendas mentioned. The only one that I had a chance to review in brief was the Housing Commission agenda. Issuing bonds, accepting proposals for bonds have deadlines. Furthermore, the Housing Commission is to provide housing, so that's their mission, that's their day-to-day operations. So you've got, from what I can see, at least without having more information, the two parts of Provision 3 met. Now, I haven't looked at New Orleans agenda, I haven't looked at Baton Rouge School Board. Caddo Parish School Board is doing live in-person meetings. I've talked with their attorney, and we're in agreement on this. We know that there is a limitation. If there wasn't, there would be no need for a special certification. And regarding whether or not the president sets the agenda, the presiding officer has to certify that, and it could be your vice president in some cases. It's not always going to necessarily be your president. It's whoever is presiding or going to preside over that meeting has to certify that the agenda items meet one of the three categories as defined by statute. And so as long as he's comfortable certifying that, that it meets those categories, then that's fine. If it doesn't meet those categories, you know, it may end up being for a court to decide. Nobody's going to be hauled off to jail, but there are civil penalties that I've made you aware of, and the chance that actions taken can be voided.
Okay, so again, based upon what I asked before, then first of all, the president and the vice president could, if they are able to.
President, not the vice president. The law says presiding officer.
Right, but okay, but that's true. But at the same time, it could be the president or vice president. You just said, is that correct?
Whomever is going to preside over the meeting that you've got the agenda for, say for instance, if you know Mr. Chavez is going to be out of town and Mr. Johnson's got to preside over that meeting, then Mr. Johnson will be making the certification.
Well, I think given what was said on Monday, if you recollect, our illustrious president said that he and the vice president, he invited him to help him make that decision. I'm comfortable with that. That will provide the diversity, although it says presiding officer. The second thing I would like to say in conjunction with that, if, Madam Attorney, if SB 302 had been passed prior to the time that the gentleman down in Alexandria had made his complaint based upon the basis that he made his complaint, I saw nothing in SB 302 that says anything about him having to certify, or we would have to certify that, that we were disabled. The CDC guideline doesn't say that either. It says that if you're over 65 and have underlying condition, am I correct?
Commissioner, based on what he filed a suit on, yes, you would have to certify that you are disabled to get unlimited telephonic communication into a meeting, no matter what the subjects were.
But how does that apply, may I ask, to SB 302 if because it does not state in there
that's not codified, or well, it's codified in the American Disabilities Act. But based on this case as an interpretation of the American with Disabilities Act, say for instance, somebody who could certify a disability would be able to call into the 3:30 meeting to participate.
Well, okay, well, say that the disability, take away the disability. He's over 65, which would basically, which is not covered under 302. Is that correct? It doesn't specify that he has to be under 65 in order to for 302 to apply.
No, correct. But the point is, Commissioner, 302 in this case don't have anything to do with one another. It's irrelevant. His case is irrelevant to 302, and 302 is irrelevant to his case.
I'm not understanding that, but that's okay. We'll move on, Mr. Vice President.
Okay. Commissioner, was it Epperson and then Atkins?
I call for the question on the motion, Mr. President.
Second.
Motion has been called. The question has been called on the particular substitute motion by Commissioner Epperson, seconded by Commissioner Jackson.
Restate the motion, Mr. Chair.
Would you thank you.
This is a call for the question. Is that?
This is a
Right.
call for the question here.
Okay.
And then once we vote on that, then we can restate the motion on the substitute motion.
Y'all ready for the roll
Roll
call?
call, please.
Thank you. Commissioner Hopkins,
Yes.
Commissioner Johnson,
Yes.
Commissioner Jackson,
Yes.
Commissioner Young,
Yes.
Commissioner Burrell,
Yes.
Commissioner Cawthorn,
Yes.
Commissioner Gage Watts, Commissioner Talaferro,
Yes, sir.
Commissioner Atkins.
Yes.
Oh, thank you,
Yes.
Commissioner Gage Watts. I heard you, and I heard you as well, Commissioner Atkins. Commissioner Chavez,
Yes.
Commissioner Lazarus,
Yes.
Commissioner Epperson,
Yes.
Okay, that motion passes unanimously to call for the question. And that brings us to, and I'll restate the motion as I have it written. Well, correct me if you have something different, but the motion was for a substitute motion from Commissioner Jackson, seconded by Commissioner Burrell, to continue meeting with a full agenda on via Zoom, and to have legal pursue legal action to challenge these new changes to the public meeting law. Via Zoom, and to have legal pursue legal action to challenge new changes to the public meeting law.
Okay.
You cut,
Regular roll
Mr.
call.
Chairman.
Can y'all hear me okay?
Okay, now, do.
Okay,
Did
were y'all
everybody
able
hear
to
the motion?
did everybody hear the motion?
No.
Yes, sir.
I
Could you
heard-
restate the motion,
Yes.
Mr. Clerk?
Thank you. I did hear at least one of those. So the motion is continue meeting with a full agenda via Zoom and legal to pursue legal action to challenge the recent changes to Louisiana Revised Statute 4217.1.
Okay.
Got it.
Excuse
All
me,
right,
Mr.
roll call.
Clerk, excuse me, did your motion as stated, I think the motion is to continue via Zoom with a full agenda?
It is. Yeah, I think that was the motion as it was stated.
Like as in right now?
I stipulated
No.
that we would be considering ordinances. We considering our zoning, ABO, all those things that we would not be considering special resolutions, special proclamations, petitions to urge and request Congress and the legislature. We would be doing our business as we normally would be doing.
Point of clarification.
There's no discussion because we've already called for the question.
And I have made that notation on the, that clarification about not including special resolutions or proclamation.
Okay. Roll call, please.
Commissioner Hopkins,
No.
Commissioner Johnson,
Yes.
Commissioner Jackson,
Yes.
Commissioner Young,
No.
Commissioner Burrell,
Yes.
Commissioner Cawthorn,
Yes.
Commissioner Gage Watts,
Yes.
Commissioner Taliaferro,
No.
Commissioner Atkins,
No.
Commissioner Chavez,
No.
Commissioner Lazarus,
No.
and Commissioner Epperson.
Yes.
And that gets us a 6-6 vote. So the motion does not carry.
Go to the original motion now.
So we are now back to adopt resolution 58 of 2020. And that's a motion from Commissioner Epperson, seconded by Commissioner Burrell.
Point of clarification again.
Yeah, restate the motion, please, or the resolution.
So that's the one moment, let me get you that language. That is resolution number 58 of 2020, a resolution electing to hold meetings pursuant to section 17.1 of Title 42 of the Louisiana Revised Statutes and otherwise providing with respect thereto.
Point of clarification.
We've called for the question, so we can't have any discussion.
I thought that was on the substitute motion.
That was on everything pertaining to that particular, the substitute and the regular motion. If I'm wrong, somebody will tell me.
Well, then, Mr.
You're correct,
Parliamentarian.
Mr. Chairman.
Okay.
What about the legal or parliamentarian? Is that the case?
I would yield to the legal counsel on that matter.
Vice President is correct, commissioners. whenever we have a call for the question, all debate stops and we vote on everything on the floor, from substitute down to original.
Yeah, but if we vote it down, we're gonna have to conform to 302.
Are we,
Okay.
are we ready for the roll call?
At least it's supposed to push it off.
Yeah.
I'm committed to it.
Roll call.
Okay, thank you. Commissioner Hopkins,
No.
Commissioner Johnson,
No.
Commissioner Jackson. Commissioner
You
Jackson,
muted.
I didn't hear a response.
No.
Okay. Commissioner Young,
Yes.
Commissioner Burrell,
Yes.
Commissioner Cawthorn,
No.
Commissioner Gage Watts,
No.
Commissioner Taliaferro,
No.
Commissioner Atkins,
No.
Commissioner Chavez,
No.
Commissioner Lazarus,
No.
and Commissioner Epperson.
No.
Okay, that motion does not carry. It has 10 in opposition, 2 in support. And at this point in time, I'd like to just note that we have had a public commenter that called in during the debate for that last item, and they are still holding on.
Mr. Vice Chair,
Yes, sir.
is there an option on the agenda at this point in time for a comment? In this space? I don't see it on the agenda.
Yeah. Well, we had the public comment earlier. The person been holding on, but we was in debate, and I told him to
Okay.
hold it.
All right.
Okay, go ahead, Mr. Clerk, and let them talk. They have 3 minutes.
Thank you. Deputy Clerk, can you connect the caller now?
Hello, sir. You're still online for comments, citizens' comments? Okay, I'm going to put you on speakerphone. Just state your name and you have 3 minutes. Okay, hold on 1 second. You can go ahead and state your name and go ahead with your comment. Can you hear me, sir? Can you hear?
Hello, are you there?
Yes, sir, we're here.
Okay. Yeah, I'm just curious as to why y'all cannot meet in person, and also what y'all have actually done for the community besides meet and disagree over things, and why I'm not gonna have recycling pickup here in a few weeks. Is that because of Republic, or is that because y'all failed to deal with it? I think it'd be a great idea for y'all to all quit your jobs, and then the little salary y'all getting combined would fix at least 1 street a year. Y'all can start like around Peach Street area, and then work your way towards downtown. I mean, you're at least 1 street a year. I mean, y'all discombobulated Line Avenue. Downtown's about to be a mess, and you got the DOTD diverting traffic to Bossier. I don't see why we keep electing all of y'all into office and y'all are literally getting nothing done. And I would divert my time, the rest of my time, to whoever wants to take over.
Does that conclude your comment, sir?
Yes, ma'am.
Okay, and just for the record, could you go ahead and state your name?
My name is Joseph Nocta. I live at 806 Columbia Street.
Thank you so much, sir. You have a good day.
Yes, ma'am. You too.
Bye-bye.
Next item, Mr. Clerk.
That brings us to the end of our agenda.
Vote to adjourn.
Second.
Second.
Everybody have a good day.
You too.
Thanks, VP.
y'all.
Thank you.